Hey, Attorney Andrew Bethel here, and today we're revisiting a touchy subject, blended marriages and A-B split trusts. This topic came back into focus recently when I had a couple come in for estate planning, and while they weren't a blended family, their concerns mirrored the same issues that arise in those situations. Specifically, the wife didn't want the husband to have the ability to disinherit their children if she were to pass away first. That conversation sparked a deeper dive into A-B split trusts, their purpose, how they're structured, and the trade-offs involved. If you're in a blended marriage or even a traditional one where you have some, shall we say, concerns, then this is for you. So grab your coffee, like the video, subscribe, and let's dive in. Let's start with the basics. An A-B split trust is an estate planning tool typically used in marriages to address specific concerns about preserving assets. It gets its name from the way it splits into two trusts, two separate parts, when the first spouse dies. Trust A, Survivor's Trust. This contains the surviving spouse's share of the assets. It's amendable and revocable, meaning the surviving spouse can make changes to it during their lifetime. Trust B, Decedent's Trust. This contains the deceased spouse's share. It's irrevocable, meaning the terms are locked in after the first death. Beneficiaries, trustees, and assets cannot be changed. The purpose of this split is twofold. First is to ensure that the deceased spouse's share is preserved for their intended beneficiaries, like their children from a previous marriage. And the second is to allow the surviving spouse to benefit from the deceased spouse's assets during their lifetime, typically through income or some limited access to the principal. So why consider an A-B split trust? Well, if you're in a blended marriage, you may want to protect your children from being disinherited after your death. This is especially important if you have children from a previous marriage, your spouse has children from a previous marriage, or you've brought enough separate property into the marriage that you want to ensure it goes to your heirs. For example, let's say you and your spouse have mixed assets. Some are separate, some are community property. You want to combine these assets into a trust, but also want to ensure that your children still inherit your portion. An A-B split trust can balance those goals by safeguarding your share while still providing for your spouse. Let's discuss why an A-B split trust can be a good choice. First, asset protection for the heirs. The B trust ensures that your portion of the assets are preserved for your intended beneficiaries. Your surviving spouse can't change who inherits those assets. Second, ongoing support for the survivor. While the terms of the B trust are irrevocable, they often allow the surviving trust to receive income from those assets or even access principal under some limited or certain conditions. And third, harmony within the blended family. By setting clear boundaries and expectations, you can avoid conflicts between the surviving spouse and stepchildren over inheritance. Everybody may get along now, but that easily changes once one of you dies. If the legal framework is there to ensure those stepchildren will receive something, then we can hopefully avoid the pestering that can occur from those who expect an inheritance. Of course, every estate planning strategy comes with trade-offs. Here are some to consider with A-B split trusts, beginning with the largest one, tax implications. The assets in Trust B only get a step-up in basis once, at the first spouse's death. Any appreciation in value after that point is subject to capital gains taxes when the beneficiaries eventually sell, even for that appreciation that occurs prior to them ever actually owning anything. This differs from a standard revocable living trust, where all assets receive a second step up at the surviving spouse's death. I have a lot of videos where I've discussed step up in basis on this channel, so I'll link to one in the corner as well as below. But just know that when an asset is received as an inheritance, the appreciation that occurred on that asset while the decedent owned it is generally exempt from being taxed as a capital gain if/when the beneficiaries ultimately receive it and sell it. The next trade-off is the administrative burden. Trust B becomes a separate taxable entity. It requires its own tax return from the date of the first spouse's death onwards. The surviving spouse must manage record keeping, file returns, and potentially provide accountings to the beneficiaries of that B trust. And lastly are the ongoing costs. Preparing and filing separate tax returns for Trust B incurs ongoing expenses. Not to mention the fact that the trustee would have to provide an annual accounting to the beneficiaries of that B trust, which would also include those who are not to receive anything until the death of the surviving trustor. These costs can add up over time and could mean stepson has standing to audit your management of your own money, or at least the money your deceased spouse left to take care of you for yourself. If the administrative or tax burdens of an AB split trust feel like too much, and they often are, there are other strategies to consider, especially if your assets are mostly separate. You could create separate trusts for each spouse. Each spouse creates their own trust and determines how their assets will be distributed. For joint assets, like a family home, each spouse can place their share in their individual trust. Additionally, you and your spouse each could leave the other a life estate in that property. For a shared primary residence, you can grant the surviving spouse a life estate, allowing them to live in the home until their death, while ensuring ownership ultimately passes to your intended heirs, even if it's only your half of the property in question. Going further, however, even without a formal AB split, you can include provisions in a standard trust to ensure certain assets or percentages are preserved for your children. Using the case of the husband and wife where the wife was concerned about the children being disinherited, they are requiring that upon the first death of either spouse, no matter who it is, half of the estate is to be distributed to their children, with the remaining half staying with the surviving spouse. Now they'll lose the second step up in basis, and the surviving spouse is going to need to get their kids' permission to sell the house if that needs to be done, and they'll only get 50% of the sales proceeds, but it does ensure that their children won't be left with nothing if, let's say, the surviving spouse remarries. Deciding whether to establish an AB split trust depends on your specific goals and circumstances. It's ideal for blended marriages or a situation where there's concern about preserving assets for children. However, you need to weigh the benefits of asset protection against the potential costs and complexity. AB split trusts can be a powerful tool, but they are for everyone. If you're in a blended marriage or are worried about how to balance providing for your spouse while protecting your children's inheritance, now's the time to start planning. Let me know your thoughts in the comments below. Do you think an AB split trust would work for your family, or are you leaning towards another approach, maybe separate trusts altogether? As always, thank you for watching. Don't forget to like, subscribe, and share the video with anyone in that family who's on their second marriage. I'm attorney Andrew Bethel, and I'll see you at our next meeting.